Good morning. This is Bob Nichols with Bracewell. I'm here with my longtime partner, Tim Wilkins. Tim and I have worked together for a long time on self-auditing. The focus of my practice for 30 plus years has been occupational safety and health. And Tim Wilkins is an absolutely superb environmental lawyer with many years of experience. We're talking together today, and we've worked together many times on self-auditing because obviously EHS, right? Environmental health and safety often go together, and many of you are committed both in your careers to environmental and occupational safety and health, and that's what led Tim and I to work on self-auditing projects together over the course of the last 20 years or so. So we want to talk a little bit today about how to and the history of self-auditing and the legal concerns involved. It's one of our favorite topics, and it's a topic of great value to our clients, both because it actually enhances environmental stewardship, it enhances occupational safety and health, and it helps you avoid regulatory and compliance problems with federal and state agencies. So with that said, let's get started. A couple of administrative matters. Number one, this is approved for CLE. We'll be sending you an email, the firm will, with information about the CLE credit sometime after today. Secondly, I don't anticipate that we'll have time for any questions, but we want to answer any questions you have. And as you know, we have our question box on the upper right-hand corner of your screen. If you submit those questions, I promise that Tim or I will get back to each and every individual submitting a question, either by telephone or email, with our thoughts. And with that said, let's proceed. I want to start with a broad overview of what we're going to talk about today. We're going to talk about a variety of devices that can help you protect your self-audit results from disclosure by federal state agencies or in litigation. And Tim is part of discussing this from an environmental perspective, is also going to discuss something that goes hand in hand, which is disclosure opportunities that exist under environmental law that can be important to you as part of the self-auditing process. So we're going to start by talking about OSHA's self-auditing policy adopted in 2000, and then, strangely enough, also adopted in 2000. We're going to discuss the EPA policy, and Tim's again also going to address EPA disclosure issues, and Tim's going to talk about self-auditing issues at the state level and certain privileges. I'm going to discuss some old-fashioned evidentiary privileges that the lawyers on the call are well aware of, the attorney-client privilege, the work product privilege, and we're going to finish up with Mr. Wilkins giving you some of his sage advice on how to effectively formulate a self-audit program and how to carry it out. Let's begin with the discussion of OSHA's 2000 self-audit policy, both what it includes, why it's important, and in some respects, how it doesn't always function the way we would like. Let's begin with some important history about how we came to have an OSHA self-auditing policy, because there's some real important public policy concerns and political concerns that led to that policy and are important to some of the controversies we've had about that policy and self-auditing generally since that time. Certainly in the 1980s and well into the 1990s, there was lots of discussion about the value of self-auditing, but there was little in writing recognizing the value of self-auditing. There was discussion during those times, by the way, of whether there should be a self-critical analysis privilege recognized under federal or state agency law or by the courts. And by and large, the conclusion was a self-critical analysis policy or privilege for the most part doesn't exist. So we were going to have to look elsewhere for protections for self-audit results. In 1991, recognizing the value of self-auditing, Secretary of Labor Lynn Martin, under the first President Bush, sent a letter to all of the Fortune 500 CEOs urging them to engage in health and safety self-auditing. However, at the same time, the agency, her agency, the Occupational Safety and Health Administration, continued to do what they'd done since the OSHA Act had been passed in 1970, which was whenever they saw fit, they would ask employers for their self-audit results. And if the employer didn't voluntarily provide them, they didn't hesitate to provide a subpoena. And under the Occupational Safety and Health Act of 1970, OSHA has almost unfettered subpoena power, both in terms of obtaining documents and compelling witnesses to testify under oath, as long as whatever they're seeking has at least some peripheral connection to occupational safety and health. In 1992, a federal district judge in a subpoena fight, in fact, recognized that OSHA has the power, under its broad subpoena power, to seek self-audit results. The court indicated whether that's good public policy or not. Congress gave the agency that authority in the 1970 OSHA Act. In the late 1990s, members of Congress, particularly Republicans in Congress, became disenchanted with OSHA's continuing subpoenas for self-audit results, while at the same time, like Secretary Martin, telling employers they should engage in self-auditing. There are basically two big concerns with agencies getting their hands on your self-audit results. One is that if they obtain your reports, they may use them as a roadmap to go find problems. After all, they're expected to find problems. They're compliance officers, after all. And if they get your reports where you've told them where your problems exist, that saves them a lot of trouble and allows them to justify sometimes very large citations with very little effort. Secondly, another concern we have with them getting their hands on your self-audit results is one of our biggest fears in OSHA enforcement is repeat and willful violations. Well, if there's if they find a violation and they find a pre-existing self-audit report that shows you knew about that violation, that is a wonderful formula for proving up a willful violation. So that's another fear we have in allowing regulators to get their hands on your self-audit results. Congress recognized these concerns. They wanted protection for self-audit results, but in response, OSHA took action to try and avert federal legislation. Specifically, in 1999, the then Assistant Secretary of Labor under President Clinton, Charles Jeffries, announced that OSHA was working on a self-audit policy that would provide some substantial degree of protection from compelled disclosure by OSHA of employers' self-audit results. Jeffries admitted at the time that his motivation for adopting the policy was in part to stop Congress from acting on their own, and he made broad promises that the policy they would adopt would help employers understand self-audits will always work to their advantage and never to their disadvantage. Well, things are seldom that simple, and they weren't simple in this case. So in July 2000, OSHA, in fact, adopted their policy entitled, open quote, Treatment of Volunteer Self-Audit and Health Safety Audits, close quote. OSHA expressed the view that self-auditing is generally a positive activity in that policy. OSHA also announced that in that policy, in the introductory section, that it generally would not use such reports as a means of identifying hazards upon which to focus their inspection activity. There were four key components to OSHA's policy on self-auditing. Number one, as I just indicated, OSHA specifically promised it would refrain from routinely requesting reports of voluntary self-audits at the initiation of an enforcement inspection. Two, OSHA promised that it would refrain from issuing a citation for a violation that an employer had already discovered through a voluntary self-audit and had corrected prior to the initiation of the OSHA inspection at issue or an accident which had led to the OSHA inspection, if the employer had taken appropriate steps to prevent the recurrence of that condition. Third, OSHA's self-audit policy provides that if an employer is responding in good faith to a violative condition identified in a self-audit and OSHA discovers the violation during inspection activity, OSHA will not treat that portion of the report as evidence of willfulness if the employer is taking diligent steps to correct the violation and bring itself into compliance while providing effective interim employee protection. You know, that's very easily said by the government. I want to emphasize in practice, many of you seen that you simply can't correct violations you find with a snap of your fingers. Often there's capital expenditures that are involved in correcting concerns. That involves budgets, that involves approvals, and not uncommonly that involves weeks or months or even years of delay before abatement action can be completely taken. So the concern for our clients with this item 3 is very often before they've had the opportunity to take appropriate abatement action, but after they've discovered the violation, perhaps OSHA will walk in the door, and then they will use what they find from self-audits as evidence of willfulness. Finally, OSHA's self-audit policy provides that employers might get a break on fines if they're diligent, good self-auditors. I can tell you from having dealt with many OSHA fines over the last 30 years and many since this policy was adopted 20 years ago, I've seen little indication that they consider a good self-auditing program in reducing fines. Let's talk about some of the deficiencies and concerns with OSHA's policy and self-auditing. First of all, please note that OSHA only said that it would not routinely seek self-audits at the outset of an inspection. Secondly, OSHA made no promises about seeking self-audit results at other subsequent phases of the inspection. Again, Jeffries and the policy itself promised us that the overall theme would be OSHA would respect employers' self-auditing and generally not seek those results. However, while those aspirations might all be well and good, in practice, employers sometimes can take little solace from them. First of all, OSHA insists in litigation frequently they're not bound by their self-audit policy. This was not notice and comment rulemaking. This is a policy which OSHA is not bound by, and they make that point frequently. And we saw the problem with that under the Obama administration. Dr. David Michaels, who was the administrator of OSHA, was a vigorous protector of occupational safety and health. And as part of that process, he took the general approach, as I sometimes heard inspectors describe, that I am your regulator and not your friend. And that pretty much summed up the very aggressive approach to occupational safety and health under that administration. And part of that aggressive approach was, again and again, I saw regulators during that 8 years ignore the self-audit policy blatantly and seek self-audit results in violation of that policy. Again, I saw it in, for example, I remember with an explosion in Louisiana in a subsequent OSHA inspection where a young OSHA compliance officer in New Orleans told me not to quote to her their policy, and she would decide whether or not to follow their self-audit policy. I had a very interesting, productive discussion with the area director in Houston, a very good area director, Mark Briggs, where he pointed out that at the time that there were times when they are going to seek self-audit results, whether we like it or not. And as I often like to point out, when we had that discussion, Mr. Briggs suggested that it might be wise for employers to make use of the attorney-client privilege as a backstop to protect their audit results. And we're going to discuss that in detail today. Interestingly enough, these requests for self-audit results seem to have come, particularly during the Obama administration, often in the context of PSM. As many of you who deal with PSM know, you have three-year self-audit obligations under 1910-119, but many employers audit and evaluate their PSM compliance program outside the scope of that 3-year audit process, and sometimes they do it using attorneys or using consultants retained by their attorneys. And if the attorney-client privilege properly applies, they should not be able to obtain those results. We're going to talk more about how this relates to the attorney-client privilege later. But OSHA has taken the position that they can obtain PSM self-auditing results, and that's certainly the case with your official 3-year PSM 1910-119 audit. But they often seem to take that position with any auditing you do of your PSM efforts. I want to talk about the fact that courts and judges, both United States district judges, magistrate judges, and administrative law judges for the Occupational Safety and Health Review Commission, being lawyers and rule followers, have often not been very happy with OSHA's frequent disregard for their self-audit policy. Let's take, for example, a case involving BP that received a great deal of attention at the time, and it concerns a BP refinery in Ohio. In 2010, following an inspection of BP's refinery near Toledo, OSHA issued citations amounting to about $3 million in fines. The inspection issue occurred as a follow-up to an earlier settlement. Interestingly enough, OSHA felt like BP had done a very good job of addressing the prior alleged violations found in the earlier inspection and that were subject of a settlement. But in checking on the settlement compliance, they found all kinds of new alleged PSM violations, and they cited BP for 42 alleged willful and 20 serious violations for a total of $3+ million in fines. Prior to the time of the inspection, BP had hired a consultant to assist with an internal audit of safety compliance at the refinery. At the time of the OSHA inspection, the consultant had not completed the self-auditing work. There was just a draft report. After learning of the self-auditing project and before beginning its actual physical inspection, these OSHA compliance officers, who had learned apparently of the draft report, asked for the consultant's draft report. And one real practical concern, if you're a compliance officer and you want to find on a large plant where the problems are, it's a lot easier to look at audit results than it is to crawl inch by inch over a large facility like that. And certainly employers sometimes think that compliance officers take that route by seeking self-audit results. In this case, when they sought the self-audit results, BP went ahead and provided the draft reports to OSHA. And OSHA used those self-auditing results very effectively against BP. They committed the classic sin in the view of employers. They used those reports as a roadmap to go find violation after violation at the refinery, leading to the fines of nearly $3 million. After BP contested the citations, the case proceeded to the independent adjudicatory agency which decides OSHA citation cases, the Occupational Safety and Health Review Commission. Those cases are first heard by an administrative law judge who works for the commission. And in this case, a woman employed as a commission ALJ heard this BP case. At the hearing, OSHA attorneys extensively utilized BP's own self-audit results against the company in support of the $3 million in fines and violations. The ALJ, again, reading the policy, the self-audit policy of 2000, and looking at what OSHA had done, was perplexed and disappointed, to say the least, with OSHA's approach. In her August 2013 decision, the ALJ criticized OSHA for utilizing its own audit materials in a manner clearly inconsistent with the agency's policy. At the outset of an audit, they did seek self-audit results, and they did use it as a roadmap to punish the employer. The ALJ explained in her opinion, quote, although the OSHA publication is a policy and not a regulation, it provides well-reasoned guidance regarding the use of an employer's self-auditing information. The goal of OSHA's policy is to encourage employers to proactively address worksite safety through raising concerns that are inadvertently providing OSHA with a roadmap for issuing citations. Employers should not have to fear that self-auditing will lead to self-incrimination. A bit more of this really dramatic opinion from this ALJ. She explained further, quote, OSHA explicitly states in its final policy that OSHA will not use self-audit reports as a means of identifying hazards upon which to focus during the inspection. But in this case, she points out, OSHA made extensive use of the reports. The judge went on to say that the majority of the items at issue were self-identified by BP and documentation provided to OSHA. And she goes on to say, OSHA's use of self-audit reports is in blatant contravention of its final policy. She was not happy with OSHA. She did note, the ALJ, that while she was very much troubled by what the OSHA had done in this case by taking the reports and using it as a roadmap against BP, she indicated she couldn't stop the agency from doing that. she and therefore many of the alleged violations were affirmed. There was little she could do. However, what she did do in her 2013 decision is she gutted the amounts of the fines and reduced them to a paltry five-figure amount from the $3 million fine originally assessed. She could not do anything about their use of the reports, but she could use her discretion to gut the fines, and that's exactly what she did. Notably, after 5 years, the full commission considered an appeal from that ALJ's decision, and in September 2018 issued its own decision, which largely affirmed her approach, which was this just absolute dramatic reduction in the alleged fines, mostly PSM violations against BP. What is interesting is the chairman of the commission, in a lengthy footnote in the opinion, echoed the ALJ's harsh criticism of OSHA in detail for using the self-audit reports of BP against BP. The chairman warned OSHA's conduct was troubling because it would discourage employers from self-auditing. And what's interesting, a couple of things we're going to talk about today tie together here. The chairman cited a decision by a Wisconsin federal judge, William Conley, in support of the view that OSHA's disregard for its self-audit policy is legally unacceptable. Specifically, the chairman of the commission was referring to the SOLIS versus GREDE case. In that case, a federal district judge, William Conley, who I will always remember because his brother was my college roommate, again, sort of like the ALJ and BP, ferociously attacked OSHA's disregard for its self-audit policy. In August 2012, OSHA had initiated an inspection of a foundry in Browntown, Wisconsin. In September 2012, as part of the inspection, OSHA made a request to the employer GREDE seeking various health and safety documents, including 3 years' worth of their self-audits. Judge Conley, who you see in the lower right-hand corner of the slide, while a very nice gentleman, and by the way, a very progressive gentleman, an Obama appointee by anyone's account on the liberal end of the political spectrum in this case, was very unhappy with the federal government and very sympathetic to the position of the employer. When the employer refused to honor the subpoena, OSHA refused to honor the request. OSHA issued an actual subpoena demanding the production of the self-audit reports. When the employer continued to resist, OSHA filed an action in federal court to compel production of the self-audit reports, and that is where Judge Conley comes into the picture. In front of Judge Conley, seeking to compel compliance with the subpoena, first of all, the company, in resisting the subpoena, argued to the judge that the request for an order should be denied because OSHA's efforts to compel self-audit reports, first of all, were clearly in contravention of the self-audit policy we've discussed, and also, very creatively, they argued that it also violated the Fourth Amendment of the United States Constitution, contending that the subpoena for the documents represented an unreasonable search and seizure because the self-audit policy had created an expectation of privacy in self-audit results. OSHA replied to the judge, to these arguments made to the judge, by saying, we're not bound by our policy. And can I tell you, when OSHA says that, that just drives judges of all stripes crazy. They're like, why do you have a policy and then keep telling us you don't have to follow it? Also, OSHA argued the Fourth Amendment was not violated because the request was reasonable because the company had a history of OSHA violations. In his decision, the federal judge began by explaining, quote, because it leads to the compulsory production of private papers, a person served with a subpoena duces tecum by a government agency is entitled to the Fourth Amendment's protection against unreasonableness. According to the Supreme Court, reasonableness means that an administrative subpoena must be sufficiently limited in scope, relevant in purpose, and specific in directive so that compliance will not be unreasonably burdensome. And then the court recognized that OSHA, in fact, has very broad subpoena power under the OSHA Act. However, this is where the twist comes. The judge said, despite these very broad statutory powers, quote, OSHA publicly committed to limit the exercise of its investigatory authority in order to induce businesses to perform self-audits. In other words, they said, go ahead, through their policy, go ahead and conduct your self-audits. We are not going to abuse our authority and demand those. For example, at the outset of an investigation, like they did with BP and like they did with GREDE in this case. The court emphasized that the agency published its self-audit policy in the Federal Register, which constituted, quote, a public assurance with the obvious goal of encouraging companies to thoroughly investigate and correct safety and health violations. And the judge went on, as you can read here, to thoroughly reject OSHA's position that it could have it both ways. That it could have a final policy calling for self-auditing and effectively promising not to improperly seek self-audit results and then to do so. The court emphasized what is important is that it creates a reasonable expectation of privacy that businesses rely on in conducting internal safety audits. In turn, this expectation serves OSHA's paramount goal of promoting safety in the workplace. To find OSHA enjoys unfettered access to such reports without identifying a specific hazard, warning investigation would render these assurances and respondents' resulting reasonable expectations of privacy meaningless. So what the judge concluded is, if they could articulate, if OSHA could articulate that they already had reasonable facts to suspect a specific problem exists, then they can seek self-audit results with regard to that specific problem. But not knowing of a problem, not knowing if there's an issue, they can't go in and just carte blanche seek self-audit results and look for specific hazards with which they should be concerned. Accordingly, the judge indicated that unless they could articulate a specific basis for seeking some specific portion of a self-audit report on a particular issue, they were not going to get the reports lock, stock, and barrel. They would have to make that showing. So this was a dramatic turn of events for OSHA, because now we had a federal judge basically saying that by virtue of the Fourth Amendment, search and seizure protection, and your self-audit policy, you really have created some degree of legal protection for self-audit results, albeit not an absolute protection. Again, I don't want to overstate the significance of this opinion. The court recognized that OSHA has very broad subpoena powers that extends to self-audit materials, but the court made it clear that he was not going to permit OSHA to act capriciously and promise employers through a policy that they would do one thing and then go ahead and do something completely different. I want to talk briefly about another concern related to self-audit results and the self-audit policy. I want to talk about the SOLIS versus Grinnell mutual reinsurance case from 2011, which is really interesting. OSHA sought self-audit results here, but they didn't try and obtain them from the employer directly. What had happened in this case is Hosbach was the employer. It's a grain wholesaler in Illinois, and they had two employees die during a grain elevator mishap in 2010, which led to the OSHA inspection at issue. What OSHA did in this case is they learned that that a reinsurer for the company, Hosbach, had done some assessment of this grain elevator and its operations. So OSHA went ahead and subpoenaed the insurance company for those reports. In opposing the subpoena, Grinnell, the insurance company, argued to the district judge involved in the Northern District of Illinois that if they have to give up their reports on their insured, then it's going to have a chilling effect on businesses in conducting safety inspections, because as what many of you know and many of you have experienced this with your insurance companies, a service they provide is they'll come on site, they'll look at your operations, and they'll make suggestions, or they might actually insist that you make changes where they find deficiencies. This is a very productive process for assuring a safer and healthful work environment. And Grinnell argued you're going to chill that positive undertaking if you make our reports subject to disclosure. And they raised the self-audit policy, but the judge said in the end The judge was very sympathetic in his opinion, but he said in the end, OSHA has very broad subpoena authority, and it extends not only to compel production from the employer, but from third parties, and that Grinnell would have to give up the reports. And so what it points out, and I've seen this happen more than once, if you're involved in an OSHA compliance action, you need to ask yourself, do you have consultants? Do you have insurers who have reports concerning your conditions at your workplace that could be self-incriminating? And you should not assume that OSHA cannot get those reports, and they will. I have worked on multiple cases where they have issued subpoenas to our vendors, to our contractors, to our consultants to obtain reports or other information that would be damaging to our position. So remember, when you're in that posture, you cannot assume you don't have a problem, and you might need to be prepared to take your own action to try and stop that kind of subpoena. And you want to know from those providers if they receive a subpoena. Now I'd like to turn things over to Tim to talk about environmental self-auditing, in particular the EPA's policy on self-auditing, and also their position with regard to voluntary disclosure. Tim?
Hey, thanks, Bob. So we're going to talk about some of these self-auditing policies here. The issue here is that audits are legally loaded. If you uncover compliance concerns and you document those, you run the risk of creating evidence of violations and evidence, maybe even more importantly, of when the company knew that a violation existed. And those obviously have really important legal ramifications. A lot of the discussion we're talking about today is about holding audit information back to prevent it from being used against you in some enforcement proceeding. In other words, using a shield to guard against that. But there are also, under some of the policies and laws that are out there, opportunities to use audit information as a sword to go into the agencies, make disclosures, and get affirmative penalty relief. And I'm going to talk about that here for a moment. So EPA, as Bob mentioned, has an audit policy. It dates back to 2000, like the OSHA policy. And like the OSHA policy, EPA says, hey, self-auditing is an important thing to do. It helps companies stay in compliance. That's more than our own inspectors on the ground can accomplish if companies are enlisted in the cause of compliance. This policy has been around, in fact, since 1986 in different forms, but again, the 2000 version is the current version. There's obviously, on the issue of agencies coming after audit results, there's a policy like OSHA's that says EPA will not routinely seek audit reports, but it's not binding. And again, if there's already an investigation underway, EPA will request audit reports as evidence of something they're already looking into. EPA, unlike OSHA, however, has been pretty good about not seeking audit reports at the outset. It certainly has not been their policy to do so. The more important part that I want to talk about here, though, as implied at the top, is that there is a disclosure policy. There's this idea that if you voluntarily self-audit, you go out and find potential violations, you fix them, and you disclose them, you can do that in exchange for penalty relief. So EPA's audit policy has 9 conditions. I'll just go through them very quickly here. It's got to be systematic discovery. You can't just trip over it. It's got to be a conscious effort to investigate compliance. It's got to be voluntary in the sense that you can't say something that you're required to do is a voluntary audit. You can't say that going out and sampling your wastewater discharge is an audit. That's something that their permit requires you to do. So it's got to be voluntary. You've got to disclose promptly with EPA. Within 21 days of the day you discover a violation, you've got to make that disclosure. The discovery and the disclosure have to be independent of the government or third-party plaintiff. If you get an inspection from an agency, they find a violation, it's too late to audit that violation. If a third-party plaintiff sends you a citizen suit notice saying you got a violation, it's too late. You've got to correct and remediate within 60 days after discovery. 60 days seems really short in the environmental timeline, but you can get extensions if appropriate. You have to take steps to prevent recurrence. This is probably obvious. Also, no repeat violations. This is maybe a little less obvious. Obviously, you don't want the situation where somebody has had something they've been cited for, they break that same law again and then they claim immunity for it. That doesn't work. But it's not that you've had a violation historically. If it's not been detected, it's not a repeat violation. It's got to be violations that have been cited before. They do exclude situations where there's serious actual harm or an imminent substantial endangerment to the public. And of course, they require you to cooperate. So for the longest time, EPA allowed you to make paper disclosures to the regional office where your facility is located, or to headquarters if you've got multi-region operations where you've detected potential violations. As of 2015, though, EPA decided they had devoted maybe too many staff around the country to this program, and they tried to make it more efficient by building out an e-disclosure portal through the CDX system that they use for a lot of the annual reporting that you do to EPA. For most disclosures under the Emergency Planning Community Right to Know Act, the Tier 2 issues, the TRI issues, you make a disclosure through this portal, and if you meet all 9 criteria and explain how, they will issue you a notice of determination that says, thanks for coming back into compliance, no further action, no penalty. All other disclosures you submit through this e-disclosure system, and you'll get a written acknowledgement that you've made the disclosure, but they're not going to issue you a notice. They're not going to say you're done, but you can have that in your back pocket if the EPA pursues an enforcement action against you later. And I've seen this done to very good effect. I've seen a situation where Region 6 had started enforcement proceedings and the company pulled out of its back pocket the audit disclosure that they had made through the e-disclosure portal, and the agency shut down the enforcement action immediately. It was really effective. So just because it worked really well in that one situation, though, I wouldn't say you should always use EPA's audit policy. There are very specific scenarios where you would want to use it first. I'd really want to focus just on federal lead programs. The EPRA stuff that I mentioned, the Tier 2 TRI, the RMP program, Risk Management Plan program under the Clean Air Act, is federal only. It's not a state program, not state implemented or delegated. Spill prevention, control, and countermeasures, again, federal program, not delegated. And then under the Clean Air Act, the fuel standards, ozone depleting substance, Title VI stuff, greenhouse gas reporting provisions under Part 98. Those are not state requirements. Those are federal lead requirements and not delegated. These are ones where you might want to think about making a disclosure to EPA. And again, you don't want to make a disclosure on everything that you might find in an audit for those. I'd say that you want to really focus on situations where you can't correct the violation without the agency learning of the gap, without it coming to the agency's attention. And so if you're going to surface the information to EPA anyways, I don't know why you wouldn't go through the audit door at the agency instead of going straight to the program. If you go through the audit door, you've at least got a colorable argument for penalty relief if the agency decides that there's a problem. There are circumstances, though, where you can't just fix and forget a finding. Let's, for example, an internal record keeping issue that you just need to go get the manifest from the disposal facility. You do that, you're back in compliance, right? But there are things in the past that might leave a mark in your records. For example, if there's a requirement to do inspections on a weekly basis, and oops, when that guy was on vacation for a month, you didn't do inspections that month, that's going to be a gap. It leaves a mark, and an inspector might find it someday. That's one you might consider using audit disclosure for. One thing that I've heard people say is they're really worried if they make an e-disclosure, EPA is going to come back after them and start investigating. The odds of that are incredibly low. EPA has been asked to publish the percentage of disclosures that have been made via e-disclosure, that there's been some form of follow-up. They haven't, but anecdotally, in talking with the National Audit Policy Coordinator and counsel at EPA headquarters, they do almost no follow-up on these. EPA has this audit policy, but many states also have policies or laws, sometimes it's statutory, where they provide either an evidentiary privilege for audit information. This is akin to the won't routinely seek, except it's potentially legally enforceable, at least in the states with the statute, that they won't allow audit information to be used against you in some proceeding, typically civil and administrative proceeding, typically state-only proceedings. But there's also an opportunity for penalty relief for disclosures that's very similar to what EPA's audit policy allowed. You've got a link here to EPA's page that lists all of the state audit policies, privilege and immunity laws and policies that are out there. The Texas Act is a really good one. It's a leading program. It provides for both an evidentiary privilege barring the use of audit information in state proceedings, and also disclosure. You can obtain penalty immunity if you find, fix, and disclose. The Texas Act is tricky, though. There are some procedural tricks. You have to notify the agency, TCEQ, or the Railroad Commission, as the case may be, before you commence the audit. You have to disclose by certified mail. We've got a question pending with TCEQ right now, whether they're going to make an exception to certified mail disclosure during the current times because of the difficulty of physical mail versus email. And there's special information needs that TCEQ requires. So successfully using it requires careful planning, thinking it through, making sure that you're going to take all of these steps. TCEQ provides better timelines than the EPA policy. They provide 6 months to do the audit, 6 months after that to make your disclosure, and then 6 more months after the disclosure to complete correction. So much more lenient than the 21-day, 60-day thing. But still, this process requires real care. You have to pay attention to jurisdiction and not disclose something to TCEQ or to the Railroad Commission that is a federal-only issue, or that is off-topic, an OSHA issue, a DOT issue, a PHMSA issue. You have to be careful about your language. Obviously, this is, again, legally loaded stuff. And once you disclose it, it may become public information at some point. You would lose a privilege by making a disclosure. And there are a number of eligibility factors that you need to make sure you tick those boxes.
Tim and I have spent quite a bit of time today talking to you about agency discretionary self-audit policies, not law, but policies. And bear in mind, not only is it important because not only is, for example, OSHA not legally bound in theory by their policy, but courts are not bound by their policy. And in tort litigation, the litigants are not governed by agencies' self-audit policy. What matters in those settings, and what can matter in agency investigations more than anything, is the traditional evidentiary privileges that we've had forever, most notably the work product protection, and most importantly, the attorney-client privilege. The first evidentiary protection I want to talk about is the work product doctrine. Obviously, it does not apply to routine auditing that you might do, because after all, you have to be acting in anticipation of litigation. As the lawyers on the call understand, that anticipation of litigation is triggered often by an accident, a demand letter, some event that creates this apprehension that you might find yourself in administrative or court litigation. Then the work product doctrine may apply. The contours of the doctrine are relatively complicated, but it can be of value when you're doing post-incident work. And post-incident auditing does occur. Tim and I have both been involved in it, where a problem has been discovered and maybe you're trying to understand the scope of the problem, or you're trying to understand if the same problem exists at other facilities. So when you engage in auditing, well, in that instance, the work product doctrine, in addition to the attorney-client privilege, might be important. So, for example, make sure your captions or your footers on documents invoking privilege properly also invokes the work product doctrine in that instance. While work product doctrine is not strictly limited to attorney communications, for example, an employer's or a company's own reaction to an incident or accident can be subject to the attorney-client doctrine, even if it doesn't strictly involve a communication to or from a lawyer. The fact remains is the strength of a work product doctrine argument is strengthened by the involvement of a lawyer. So for a lot of reasons, involve lawyers early and directly when you've got a serious legal problem, such as an accident or a legal demand. Next slide. Now I want to talk about the attorney-client privilege, something that Tim Wilkins taught me a long time ago can be your most valuable friend in protecting self-audit results. One of the reasons it's so important is it's not a discretionary policy that an agency can choose to follow or not follow. It's not simply applicable in agency actions, but it is. You can resist a government subpoena in an agency action based on the attorney-client privilege, but it's also important in all types of litigation. So the attorney-client privilege can be of great value. Now, it's different in scope than the work product protection. First of all, it has to be communication between client and attorney, or the client's agent and the attorney, or the attorney's agent. It must be a lawyer acting in their capacity as an attorney, as a legal advisor, and this comes up with in-house counsel all of the time. They sometimes act as business advisors or financial advisors for their companies. If they're acting in those capacities, then the attorney-client privilege does not apply. The communication has to be for the specific purpose of rendering legal advice. The communication has to be confidential. And that means everyone involved has to keep it confidential, and that means people inside the company should not share it with other people inside the company unless there's a strict need to know. Normally, they shouldn't feel like they can share it with anyone, even someone in management, unless they're doing so at the direction of counsel. A key issue that comes up is when you involve a third party like a consultant or other vendor. When can they be part of the attorney-client privilege communications? And that raises a key case, the Occupational Safety and Health Review Commission's decision in Delic Refining. In Delic Refining, OSHA made an effort to argue that when employers use third-party consultants for safety and health auditing, even when counsel is hiring the consultant, they argued that often the attorney-client privilege has no application because a third party is involved, not just the client and the attorney. This arose out of an incident at Delic Refining's Tyler, Texas refinery. Following an inspection by OSHA of that refinery, 2 PSM citations were issued. After Delic contested those 2 citations, an administrative litigation began before the commission. The Secretary of Labor then issued a subpoena during the administrative litigation to a third-party company called Process Safety and Reliability Group. This was a PSM consulting group that was retained by Delic's counsel to provide analysis. This was not part of their 3-year self-audit for 1910-119 purposes. They were doing their own independent work, the lawyers were, to try and see if there were PSM deficiencies that needed to be addressed, and they were doing it under privilege. And they retained an expert, as we do, as Tim's often done, as I've often do, to assist with that analysis. When the Department of Labor tried to get the TSRG's reports during that administrative litigation, Delic filed a motion to quash before the ALJ, arguing that the reports were protected by the attorney-client privilege. After all, I, attorney for Delic, or whoever the attorney was, said, I retain this consultant. You can't see our work product. So the issue before the Occupational Safety and Health Review Commission was, when does the attorney-client privilege extend to a report created by a third party, not created by the client, not created by the lawyer, but by a third-party consultant hired by the lawyer to assist with some health and safety legal work. And in response, the commission articulated a 3-part test, and all 3 parts have to be met, according to the commission, for the report of that third-party consultant to be subject to the attorney-client privilege. Now, I will tell you, and some of my litigation partners remind me of this, this test is relatively tough on employers and is relatively narrow in scope for those trying to assert the attorney-client privilege. There are certainly federal courts that don't take such a restrictive view of when third-party consultants' reports may be subject to the privilege, but for purposes of occupational safety and health, what the commission thinks is important, and they created this 3-part test. First of all, they said the consultant must obtain the information addressed in the report from the employer and not gather the information itself. And this is something that was really troubling when this case came out because of the way many consultants function. Specifically, the commission said the privilege does not apply where attorneys employ the third party to go out and gather their own observations and data on physical conditions at the client's site. Rather, it's got to come through client confidences. So their position is if you simply go out and look at the refinery and then render it advice as a consultant, the privilege doesn't apply. I'm not sure I agree with that. But something I have done in response to this, and it's often appropriate regardless, is I want to make sure we incorporate interviews of health and safety personnel, of plant management, of others in the work that's done, because then the argument becomes a substantial part of the work product is not just observing the facility, it's speaking with the client's representatives, and then translating that information as we'll discuss, synthesizing that information technically for the lawyer. And what we try and do is we try and draft retention letters with third-party consultants that trace the elements of this test. The second element that the Commission established in DELIC for the applicability of the attorney-client privilege to a third-party consultant's report is the employer sought legal advice rather than just technical advice. So, for example, if you hire a consultant just to figure out how least expensively or most efficiently to correct a condition, for example, to erect a barrier, and that's all that's happening, there's no legal advice there. So one thing that's critically important, and Mr. Wilkins taught me this a long time ago, is that you make it very clear in all of your documentation that the whole purpose of this endeavor that you're involved in is to aid in the formulation and rendering of legal advice. And I can tell you, if you pay, I don't want to say this is absolute, but if you paper the file properly, if you say the right things in your retention letters, if you say the right things in your emails, then you're going to go a long way toward convincing any judge or any agency that it's privileged. So your document should parrot these three requirements. The third requirement is the employers are the attorneys needed the consultant to improve their comprehension of information by the employer so that they could effectively render legal advice to the client. Consultants must serve as a translator or interpreter, the court said. So this is the way we usually try and formulate it, okay? We have a technical expert. Maybe it's a PSM compliance expert, an engineer perhaps. And they are going out and observing conditions, but they're also talking to our client and gathering information from the plant folks, including plant management and health and safety representatives. And then they are putting that information into a format, a report to the lawyer that allows the lawyer to understand the conditions at issue, to understand the information provided by the plant. So the consultant is facilitating, is translating between, for example, plant personnel and plant conditions and the lawyer. So that's the way we try and formulate it. And under the case authority, I think if you formulate it that way and your documents read that way, no one's going to argue credibly that the consultant's report is not covered by the attorney-client privilege. So as we've discussed, you need to carefully follow this three-part test in formulating your relationship with your consultant. Your retention letter should reflect this. And again, you need to remember that your communications should not indicate that the third-party consultant is just going to go out and look at working conditions or look at the facility, but because according to the Commission, that in and of itself is not a privileged undertaking. And as we've talked about, you want to formulate all of your documentation consistent with this test. Let me turn it back for Tim Wilkins to finish up. Again, Tim is as good as anyone I know when it comes to talking about the basics of how to put a audit program to effectively and what to do and not do to try and enhance, among other things, the application of the attorney-client privilege. Tim?
Thanks, Bob. So I'm going to talk a little bit about audit program implementation. We know that a lot of companies out there don't bother protecting routine audits with attorney-client privilege. Sometimes it's just not on the radar of the people who are running the audit program to do that. Privilege can certainly be cumbersome. It puts an additional layer of bureaucracy into the process by having the lawyers oversee it. It certainly creates a perception in some that it impedes the broad sharing of compliance knowledge and best practices. I think there are lots of ways to get that information out there without breaching privilege. And companies also may have programs, audit programs that have been going on for decades, and they don't find problems of any significance. And so why would they incur additional expense to protect the audit report under an attorney-client privilege? If you choose not to use privilege, though, I think it's really important to still maintain some minimum safeguards around the way you practice these audits. You should always carefully control the written work product of an audit. As I've said, this stuff is legally loaded. We are talking in written reports about compliance problems we have. If that ends up being evidence against you, and it certainly will if something goes horribly wrong and you don't have a privilege shield on it, but there are things that you can do to make sure that that written work product is not damaging if it does come out privileged or not. Audit write-ups are often overstated, inflammatory words. People make mistakes or overcharacterize what they've seen. They recommend corrective actions that are, one of a menu of potential options that you could pursue, but they only take on one of them. There are lots of ways that audit reports can be problematic if they are not carefully prepared and carefully controlled. I think you should always have a conversation among all of the stakeholders before you document audit findings to make sure everybody's aligned on the fundamental conclusions, on the approach, on the tone, and so forth. You should also carefully control any note-taking by individual team members because that stuff's, especially in the absence of a privilege, that stuff's going to be admissible too, and note-taking can be really careful, or it can be really problematic because people aren't careful in what they do in terms of notes relative to the final product they may prepare. You should always carefully plan this process from the beginning to the end. Are you going to be ready for the results when you get them? Are you ready to act on corrective actions? Do you know who's going to be the ultimate recipient of the report information and how that information is going to be used? You know who's within the need to know group for this stuff? Those are things that you should think of before you get kicked off on the audit itself. If you do choose the attorney-client privilege route, this does require material involvement of legal counsel. This is not just making sure that an attorney someplace is CC'd on emails about this process. There needs to be active involvement. The process should be carefully documented. Bob mentioned this, but to support the privilege claim, start with a written communication where the client asks counsel to provide advice, legal advice on compliance status, on compliance strategies. And then if you're using a third-party consultant, or even if you're just using in-house personnel to gather the audit-related information, you should clearly document the roles and make sure it's clear that that information gathering function is to build out that interpretive reporting that Bob described, and to make sure that it is described as in furtherance of the legal advice that the attorney has been requested to provide. And of course, consider the three-part DELIC test. I agree with Bob that the first prong of the DELIC test doesn't make a lot of sense, but I think you can meet it by saying that any observations of facilities are part of this interpretation that they're doing following from the interviews where they learned that piece of equipment X has a problem. So I think you can have a blended observation / client communication that undergirds the auditor's report. And I think that passes muster on privilege every time if you've papered it properly. So I think it's important that anybody who's on the audit team who's going to be participating in the audit, hearing the results of the audit, should receive strict instructions on privilege, on confidentiality, on document handling. I think it is also, again, I'm going to go back and emphasize this point again, if you're going to do a self-audit, you need to make sure that the people who hold the purse strings at the company understand that you need to get working on correcting the identified deficiencies as soon as practicable. To do otherwise, if you say, I found this, I'm documenting it in an audit, but I'm not going to get started fixing it because it's too expensive, that's going to be arguable evidence of a knowing willful violation, and for a kicker, it's evidence of money motive for not complying. And that's a really problematic set of facts, especially under environmental laws where knowing violations are the source of potential criminal exposure. So when you have an audit that's triggered by a specific complaint or concern, like in the Valley case that Bob has talked about before, the attorney work product protection is also a supplemental belt and suspenders that you're going to want to grab onto following an incident, following a complaint, following an employee injury, any of those scenarios. This is above and beyond attorney-client communications privilege. It's another way to protect your documents. So when do you really want to make sure you're doing attorney-client communication or other privileges? You know, we've talked about how you do it, but when do you really want to make sure? I'm going to tell you that if you're going to do an audit in a situation where you have any doubt about what you might find out there, where there's a possibility of something significant that might be uncovered in the audit process, this could be a situation where you've got a new asset that you're auditing, a situation where you know there have been breakdowns in communications or programs or systems, a situation where you're auditing a facility for the first time, a situation where there's been an inconsistency in staffing, you've had turnover of environmental managers or individual staffers who are implementing programs. And I'm going to say when we return from this work from home scenario as a result of the COVID virus, when we get back to work, there are going to be things that have fallen through the cracks. There are going to be balls that have been dropped. These are good times where you might want to apply attorney-client privilege because you're probably going to find some stuff that could be bad, and that's the stuff that you want to protect from use against you as evidence when you're doing auditing. Also, if you're under any kind of extra scrutiny, if you've got neighbors who are regularly complaining and going to the agencies, if you've got media folks who are after you, especially something that's after an incident where there's a lot of microscope on you, whether there's agency or media or neighbors that are paying close attention, those are scenarios where having an audit report privilege also would be, I think, really appropriate. If there is an incident or an investigation at some later date, you will very likely wish you had an evidentiary privilege to fall back on. This is why we recommend this. Oftentimes, it ends up being unnecessary and unused, but when it does turn out to be really something you want to have that privilege there. Experienced counsel can obviously provide a smooth path to protecting the audit findings and can also help you maximize the benefits of those disclosure programs, knowing when and what to disclose to whom and when not to, I think really is an art that's developed after years and years of practice in this area, and you ought to be talking to counsel who have done exactly that if you're considering audit disclosure under some of these audit laws and policies. So listen, thank you all for taking the time to join us today. Bob and I have really enjoyed practicing together over the years in this EHS audit space, and we think there's a lot to gain from understanding how to maintain privileges, how to use disclosures and the like. Please, please, please email us or call us with any questions. You'll see on the screen our email addresses and phone numbers. Also, look for our emails that are going to be following here that'll have instructions on how to claim the CLE. Thanks again for taking the time today. I hope everybody stays safe, and we look forward to seeing you all again when this is over. Thanks.